بسم الله الرحمن الرحيم الحمد لله رب العالمين وأفضل الصلاة وأتم التسليم على سيدنا ونبينا وحبيبنا محمد حبيب رب العالمين وعلى آله وأصحابه وأتباعه إلى يوم الدين. اللهم فقهنا في الدين وعلمنا التأويل وألهمنا رشدنا يا رب العالمين. Alhamdulillah. We have been looking at the types of talaq, and we looked at the difference between the talaq al-ba'in and the talaq al-kinaya, and that the talaq al-kinaya, when does it happen? Talaq al-kinaya takes place when there is intention, unless it be taken to court. Unless it be taken to court. And we had requested that something be summarized regarding the three states. Was that done?
I think you said the diagram.
Yeah.
Yeah.
Collectively? No, question was collectively. Okay. Bismillah. Alhamdulillah. So then he says, rahimahullah ta'ala, وَإِذَا أَضَافَ الطَّلَاقَ إِلَى جُمْلَتِهَا. أو إلى ما يعبر به عن الجملة. Right? If the talaq is ascribed to her entirety. And the reason it's mentioned to her entirety because often these are from, I have, like someone said in English, for example, I've divorced your ugly face. But you can't, technically, it's the person who's divorced, right? So would that count or not, right? So they put some criteria, Someone said something rude, right? Like, I've divorced, but there's different, and sorry to use crass language, but for example, I've divorced your fat ass, for example, someone said. That's a common expression that people use. Someone did something, so what's the difference between I've divorced your that or I've divorced your popcorn nose, right? There's a difference because nobody refers to a person by their nose, right? But if you say, I've divorced your ugly face, there is a different meaning to it. So what is the criterion for that, right? What is the criterion for that? This is what he looks at. And the principle is that which is customarily used to refer to the entirety of the body or the whole person counts as divorce. And that which isn't, right, would not be considered a pronouncement of divorce. Right? That which is not considered to. So someone said, I have divorced your ugly hair. Is hair used to describe the entirety of a person? If it is, then it would count as divorce. If it's not, then it's not. Right? So that's broadly the criteria. He'll explain now the unfolding implications of that. So he says, rahimahullah ta'ala, right? وإذا أضاف الطلاق إلى جملتها أو إلى ما يعبر به عن الجملة. If the man ascribes the woman's divorce to her entirety, right? To her entirety, or to that by which her entirety is referred to, so it's referring to her, then what happens? وقع الطلاق. And what counts in that is custom. Is custom. Right? And the custom in one language may differ from the custom in another. The custom in one language may differ from the custom in another. So we need to keep that in mind. And he gives some examples. مثل أن يقول أنت طالق, right? أو رقبتك طالق. Now أنت, you, this is directly referring to the person, right? Or if he used her name, right? If he just said straight up, so and so is divorced, right? That is the most direct description to the person, is to refer to them themselves. This is obvious. Likewise, if you refer to, for example, he says, رقبتك طالق. Raqaba literally means the neck. But raqaba in Arabic is used to refer to the person, right? To the person, right? Because it's the neck is where their lifeblood flows into. That's what supports their head. Someone who, was under the control of another, like a slave, it would be there. You had them by the neck. They're under someone's control. So this expression of raqaba is used to refer to the entirety of a person, right? In Arabic. Now that does not necessarily apply in English. Your neck is divorced. Does that in English customarily refer to the entirety of a person? Not necessarily, right? So that's something to keep in mind, right? The criteria is if the divorce must be ascribed to the person or that which is customarily used to refer to the entirety of the person, right? أو عنقك طالق, or your neck is divorced, right? أو روحك طالق, or your soul is divorced, right? أو جسدك طالق, or your body is divorced, because the body refers to the entirety of the person. أو فرجك طالق, your private parts are divorced, right? Which in Arabic, so that would go back to usage, right? And this is why divorce is not a straightforward matter. And if something new arises, divorce being as sensitive as it is used, one would use in that, careful consultations, right? وجهك طالق, your face is divorced, right? Your face is divorced, right? Right? And he in the commentary he gives the reasoning. لأن هذه الأشياء يعبر بها عن الجملة, because these things one uses to refer to the entirety of the person. يعبر بها عن الجملة, how? عرفا, in the urf, right? So that's important because in different languages custom differs, right? فكان بمنزلة قوله أنت طالق. So that is akin to his saying, you are divorced, right? يعبر بها عن الجملة عرفا, right? عرفا. وكذلك, and likewise, إن طلق جزءا شائعا, if you divorce a part, a non-specified part of her. مثل أن يقول نصفك أو ثلثك طالق, right? Half of you, and this is a non-specified part because your leg is divorced, that's a specified part. Then we'd have to see, does leg is leg used to refer to the entirety of a person? Right? Maybe he's just some kind of, he wants to butcher her. And the act of butchery is not an act of divorce, right? As unacceptable as butchery may be.
Is the reason...
Okay, no, that's not a question, right? Is the reason A is not a question, right? وَإِنْ قَالَ, right? So if you say half or a third or a quarter, right? So that the ascription of talaq would apply to. وإن قال يدك أو رجلك طالق لم يقع الطلاق. But if someone says your hand is divorced, right? Or your leg is divorced, the divorce does not count, right? Because it's been ascribed to a particular place, and that place is not used typically to refer to the entirety. That place is not used to refer to the entirety of the person. So that's in terms of, and why would this arise? Because this is from the usage, right? People in pronouncing the divorce would say things like this, right? Why? For example, she got mad at him, she punched him. And I've dealt with where husband and wife have called police on each other because they've like been beat. So she punches him. So he says that, that vile fist is divorced. He says, I intended her, but is fist used to refer to the whole person? No. So it would not count as divorce. Right? Right? وإن طلقها نصف تطليقة أو ثلث تطليقة كانت طلقة واحدة. If he divorces her with half a divorce or a third of a divorce, it counts as one divorce. Because divorce is not لأن الطلاق لا يتجزأ. Because talaq cannot be divided. So he pronounced a divorce, and pronouncement of divorce counts. He then said but it's only half. So the fact that he pronounced counts, the fact that he halved it does not count. Then he says, وَطَلَاقُ الْمُكْرَهِ وَالسَّكْرَانِ وَاقِعٌ. Right? The talaq of one who is coerced, right? The mukrah is someone who has been credibly threatened with loss of life or limb. Someone who's been credibly threatened with loss of life or limb. That is what's considered legal coercion. Other types of pressure are not considered coercion. They may not be permissible, but it's not considered coercion. Right? So parents saying, well, I won't talk to you, this and that does not count as, technically, does not count as coercion per se. Right? Was sakran, and the drunk person. Now, the divorce of a coerced person, right? Why? Because the default is that divorce counts, right? And there are actions, and there's difference of opinion on this. Someone finds this difficult. There's the position of the Shafi'is that the talaq of the coerced person does not count. The Hanafis took the principle that that every divorce counts by the wording of the explicit wording of the Prophet ﷺ and the implications of what is understood from the various verses of the Quran related to divorce. So given that every divorce counts, this is a pronouncement of divorce. It counts, and they took a number of incidents where there appears to have been explicit divorce, and the Prophet ﷺ said it happened. Right? And we mentioned the case of the woman who sat on her husband's chest and said, by Allah, you will divorce me or I will slaughter you, with a dagger to his neck. and he pronounced divorce on her, that is ikrah. And the Prophet ﷺ said it happened when he went to complain. There's ikhtilaf about that. And the drunk person, this is if they're drunk with something impermissible. And again, the principle, بمحظور, with something impermissible. Shaykh al-Allam al-Maydani refers to one of the very good commentaries on Quduri, al-Yanabi', which is published. But it's, somewhat, something of the Lubab or even the Jawhar an-Niyar are easier to access for the general student. But al-Yanabi' has been published now, right? So this is when the divorce is with something that is with an impermissible substance. As for if someone took medication, for example, or something permissible, they got drunk, they got intoxicated by mistakenly eating too much nutmeg, for example, which is intoxicating, right? Don't get bad ideas, right? Or someone said thoroughly use mouthwash thoroughly, so they rinsed their mouth and said, what do I do with mouthwash? I'll swallow it. So they swallowed a whole bottle of mouthwash or something, got drunk, accidentally, not seeking intoxication. The divorce would not count because it wasn't impermissible, right? The use of, so it's those intoxicants that would be deemed by fatwa to be impermissible, right? And in general, all drugs that intoxicate are impermissible, right? Now, what if someone is mute? They can't speak. The akhras, they can't speak. So, okay, they're safe because they can't pronounce divorce. So, وَيَقَعُ طَلَاقُ الْأَخْرَسِ بِالْإِشَارَةِ, right? The divorce of a mute person counts by sign language, right? By sign, and what's meant here by sign is by sign language. بِالْإِشَارَةِ الْمَعْهُودَةِ لَهُ, with the sign that would customarily indicate, in their case, the pronouncement of divorce, right? Or in writing, right? Or in writing, or by. It can also count in writing. It can also count through their referring, their giving agency to their agent, someone acting on their behalf. Yes.
So can sign language then also count as sarih and kinaya depending on the custom of the language?
Yes, so sign language with respect to someone who needs to use it would take the place of spoken language, and the principles of language would then apply to that which is explicitly used versus that which is used by indication, etc., etc., etc. Now, what if someone divorces their wife before they get married? That sounds far-fetched, but I've seen many, many cases of this when I was in Damascus, right? Because we used to sit and have class outside the office of Shaykh Abdul Razak al-Halabi, and people would come with their divorce issues, and so this issue would come up that, let's say, for example, they're getting married, but they got fed up. They're discussing wedding preparation, and the wife wants roses, red roses. He wants pink roses. She wants to spend more on this and that. So he divorces her. But are they married yet? No. But how could a divorce count before being married? Can a divorce count before they're married? Yes, on condition, right? Which is وَإِذَا أَضَافَ الطَّلَاقَ إِلَى النِّكَاحِ وَقَعَ عَقِيبَ النِّكَاحِ. If the divorce is ascribed to the marriage, then the divorce would count once they marry. How? مثل أن يقول, for example, if he says to someone he's not married to, and of course there's no legal status to the engagement, the khitbah, is simply considered a promise with the rules that apply to promises. It's not permitted to make a promise without intent of fulfillment, but a promise is not binding per se. It can be, they could, and the engagement. But so if someone just says they got fed up with the marriage preparation, say, I divorce you, doesn't count because they're not married. But what if he says مثل أن يقول إن تزوجتك فأنت طالق? If I divorce you, then you're divorced. If I marry you, then you're divorced. Right? أو, right? And people would do things like that, right? He says, once we get married, this will count as one divorce against you. It will. It will. أو كل امرأة أتزوجها فهي طالق. Every woman I marry, she is divorced. Right? So if he marries her, as soon as the marriage happens, she gets divorced. So they'd have to conduct the nikah and then conduct it a second time, right? And if he consummates a marriage after that, without having renewed it, it's zina. But because there's a shubha, right, that they did have a marriage contract take place, the had punishment, the had of zina, the prescribed punishment for zina would not apply, because there's a shubha, which is that they did get married, and this is something that reasonably people would not be aware of, that they are in fact divorced. So that's why expressions of divorce are not to be taken lightly, because the basis is that they count where it can be reasonably considered to count.
Are these conditioned divorces considered raj'i?
Which conditioned divorce? Okay,
conditions of divorce on marriage. Is it considered a raj'i divorce or?
This is not yet we've not taken the full the idafa. Let's take the idafa first. وَإِذَا أَضَافَهُ إِلَى شَرْطٍ وَقَعَ عَقِيبَ الشَّرْطِ. If the divorce is ascribed to a condition, then the divorce occurs once the condition is fulfilled. And again, this was from the bad habit of and other people, that they would ascribe divorce to, if you do this, you're divorced. If you do this, you're divorced. And this is not a good state for the wife to be in, and it's not a good state for the marriage to be in. And so it counts. But it counts once the condition is fulfilled. Right? So he says that if he ascribes the divorce to a condition, the divorce occurs once the condition is fulfilled. مثل أن يقول لامرأته, such as if he says to his wife, إن دخلت الدار فأنت طالق. If you enter the house, you are divorced. And any time from that point into the future, if she enters the house, she would be divorced, right? And you cannot take that back. Right? So this is, these pronouncements of divorce are very, very serious, right? Right? But he says, ولا يصح إضافة الطلاق إلا أن يكون الحالف مالكا. Right? It is not valid to condition to make a ascription of talaq, right? The إضافة الطلاق, unless the one who makes this halif, makes this statement, possesses, is an owner. But an owner here, what does he own? Malikan ay lit-talaq. He owns the right of divorcing, right? That when he يعني أي مالكا أي القدرة على التصرف, right? That he possesses the right of divorce at the time of pronouncement, right? As opposed to if he did not possess the right of divorce, right? So for example, وَإِن قَالَ لِأَجْنَبِيَّةٍ, if he said to someone he's not married to, and he says, إِن أَكَلْتِ هذا الكعك فأن, so he says, if you eat this cake, you are divorced. Then they got married and they served that cake and she ate it afterwards. Does it count? No, because when he spoke, when he said that, he did not possess the right of divorcing her at that time. Right? وإن قال لأجنبية إن دخلت الدار فأنت طالق, if you entered the house, then you are divorced. ثم تزوجها فدخلت الدار لم تطلق. Then if he marries her and she entered the house, she's not divorced, right? Because when he pronounced, he did not possess the right of divorcing her, and he did not ascribe it to the state of marriage. Right? So, right? And this is called a talaq al-mu'allaq, right? So this has this talaq al-mudaf ila shart, the talaq that has been ascribed to a condition. This is often referred to as ta'liq al-talaq. Allaqa, you make that, it's a conditional divorce, right? You make it conditional upon the occurrence of something, right? And right, and there are two items in Quduri Basha's work, الأحكام الشرعية في الأحوال الشخصية, which is a very good book summarizing the relied upon rules of the Hanafi school with their conditions with respect to divorce. So items 251 and 252 describe this, right? Because talaq, right? So talaq counts, right? And talaq, it breaks it down conceptually very nicely. Talaq can be lafdhan or bil kitaba. Talaq can be uttered or it can be in writing. That's the first of two matters to consider. It can be in writing. The basis is talaq is uttered, but it can also be in writing. Then talaq can be munjaz, right? It can be effective, right? That it's immediate, it has immediate effect, or it can be mu'allaq. It can be effective, or it can be conditional. It can be mu'allaq, right? The effective talaq, the talaq al-munjaz or al-munajjaz, is that which is with an expression of divorce unconnected to a condition. The talaq that is effective is one that is with an expression of divorce unconnected with a condition. The difference between someone saying you are divorced and saying you are divorced if you eat mansaf, or if you eat this cheesecake, right? When she started eating her fourth cheesecake, right? And right, and the talaq al-mu'allaq could be it could be ascribed to a particular matter or an incident or a time. And when that matter or that incident, right? So he says, in shatamtini fa anti taliq. Right? If he says, if you ever curse me, you're divorced. So if she says something that customarily would be considered a shatima, a curse, she'd be divorced. Right? So if that matter takes place, or that incident, or that time. Okay? She said, I'm flying to New Delhi and I'm arriving there 9 p.m. tomorrow. So he says, at 9:45 p.m. you'll be divorced. You are divorced. Where's this technicality? So you will be divorced, would it count or not? That's a separate matter. It doesn't necessarily count. Which is why there are nuances to divorce, and very often there's, that's one has to look at that. Because the difference between, so it would count when you make it firm and then you ascribe it. But you say you will be divorced tomorrow. That's a threat, right? So that's why the pronouncement has to be such that if it were not conditional, it would count now, right? So it says أنت طالق غدا الساعة الثانية والنصف, it would count. But he said أنت ستطلقين غدا, you will be divorced tomorrow. That's a threat. That threat is that's a tahdeed. And it doesn't count. So just keep. So that's item 251 and 252 of Quduri Basha's. So Quduri Basha, just as an aside, there was a big challenge to Islamic law made from within the late Ottoman period, because the basis is that fiqh is that which is done by the fuqaha, fatwa is that which is done by the mufti. Right? That's what fiqh and fatwa are. And you became a faqih by training as a faqih, and become a mufti by training as a mufti. And without that training, mind your own business. You have a business, mind your own business. You don't have a business, then mind whatever else you do. So, and the fuqaha wrote for specialists. They did not write for the untrained. Right? It's a specialization. Right? So, and in that's, so you're not, and in any of the specializations in Islam, they're principles. So even, for example, which is that, yes, you could set criteria and standards for who would be counted as being from a particular specialization, but you could not exclude people who fit those criteria on the basis of race or ethnicity or them being a foreigner and so on. And there's a big history of that, and that's considered to be dhulm, right? But the self-taught person said, "La yusaddaq," like they would not be believed just like that, right? So, and that's why they said that sometimes the fuqaha mention some things unconditioned. Imam Ibn Nujaym in Al-Bahr Al-Ra'iq says, وَقَصْدُهُم مِّنْ إِطْلَاقِ عِبَارَاتِهِم. The reason they sometimes mention things unconditioned, أن لا يدعي علمهم من لم يزاحمهم عليه بركبهم بالتلقي عن المشايخ. Right? That the reason they mention some things unconditioned in one text, and in another text it's conditioned, is so that that this knowledge not be claimed by those who haven't acquired it through by sitting on their knees in the presence of the people who have this knowledge, right? So that they've gained the training, understanding. Okay, this mentioned generally, it's conditioned by that thing. That's mentioned specifically, but it's actually a general principle because it's based on that principle. So, for those who are untrained, but then internally, as the Ottoman Empire was weakening, and as a wide land, people, and the educational system was teetering internally, but there's a lot of internal pressures from those who were going to European countries, especially France, and getting influenced by the wealth and glitter of European modernity, and internally due to pressures from the reforms that Napoleon brought into 19th century Egypt, and so on, and a sense that we've fallen behind, and so on. And then external pressures, because Turkey had gotten itself into huge debt. They say debt is a fate worse than death, because someone dies, they died with dignity. But someone's in debt, it's the ultimate indignity, right? You have to beg others for clemency. So, what do you do? Right? So there's external pressures that, we will give you debt relief, we'll do this, but you must do these things. And there's pressures to adopt the French law codes and so on for personal law and this and that and the other. So the ulama, so that's how the majalla, when it came to commercial law, arose. In commercial law, the ulama, led by Allama Ahmad Jawdad Basha and others, right? And they formed a committee of notable scholars that included, amongst those who were part of the committee, Shaykh Alauddin Abidin, the son of Ibn Abidin. It also included other notables like Shaykh Amin Jundi from Syria and some of the the Ottoman scholars. And so they codified the Hanafi fiqh related to commercial law, and there's other such attempts to codify. So one of these codifications was done, and of course there's resistance to that codification because the nature of fiqh is that it has an inherent dynamism to it as well. So no codification can really be final, but it was meant to simplify the application of the fiqh to people's challenges. So the Majalla arose from this, and the Majalla was actually adopted by the Ottomans as law in fiqh al-mu'amalat, and we look at that when we come to fiqh al-mu'amalat. But Quduri Basha, who was, he compiled, and there's other attempts like the Majalla when it came to Qanun al-Nafaqat, the laws related to provision and so on. Quduri Basha did a codification of personal law, which is very influential because later, after the fall of the Ottomans, when Egypt adopted a Qanun al-Ahwal al-Shakhsiyya, in the early 20th century, a lot of pressure to adopt Western codes, and there's all kinds of pressure from modernists and secularists and all kinds of things. His effort and the effort of others after him bore fruit, and there's aspects of that Egyptian law code that can be deeply criticized because there were tough times. It's easy to be very critical that this was defeatist, modernist, reformist, apologist, and all these other ists, but it was rough times. It was really rough times. And right, it's like someone got a knockout punch and they're lying down knocked out, and say, it's sunnah to smile. Right? Poor guy just got knocked out. Like, let him get up first, right? So miskeen. So the Quduri Basha really summarized the conclusions of Ibn Abidin and the late Hanafi school in a. Now, of course, it's written like a law code, so it's very nuanced. There's a number of commentaries on it, most notably by Al-Abyani, who did a somewhat detailed commentary in multiple volumes on شرح الأحكام الشرعية في الأحوال الشخصية. Quduri Basha was very good in codification, but naming wasn't his specialty. He didn't get, I don't think he hired a marketing specialist to help. So he just called the codification of personal law الأحكام الشرعية في الأحوال الشخصية, the legal rulings related to personal law. Not very creative title. He also did a codification of the Hanafi fiqh, or the relied upon positions in Hanafi fiqh related to commercial law, called Murshidul Hayran ila ma'rifati ahwal al-insan, a guide to the bewildered to knowing the states of a human. I was once walking away from the Umayyad and walked by, the Masjid Sinan Basha, and just some guy has selling a few random books, and there's a few books that were like novels, and some of these, God knows who, authors or translators, like selling like trashy literature. And look, Murshidul Hayran. I thought it was a book in Islamic spirituality, to knowing the states of the human. It was like ridiculously cheap. It was like, at that time, like, my copy has the price. It was like 70 lira Saudi is like $1.40 US. Right? For like, I just picked it up. I had to get to another, or I had to get actually to shawarma. That was correct. If I don't know what I was planning to do, I was always planning to eat. So I just picked it up. They were like, it's Hanafi fiqh. Then I asked my teachers about it. So these are very useful books by Quduri Basha. His one on personal law has been given more attention than his one on commercial law, because in commercial law, the Majalla did not just take, which translates the Ottoman Commercial Law Code, did not just take the transmitted relied upon position of the Hanafi school. The Majalla addressed a lot of issues that were challenging during that time. We'll talk about that when we get to it. Quduri Basha stuck to what's the relied upon position in the hadith. We try to summarize the relied upon position. But the Majalla the Majalla has much that is, and actually it's simpler in language too. Because written for a lot in the rural areas, there's people who are appointed as qadi and they didn't know much fiqh because of nepotism and corruption and fitna, and so they even put things like al-ba'i' huwa man yabi', like the ba'i', the seller is the one who sells. Like they defined like everything, so it's very clear. Sometimes a bit too clear. Had been written 200 years before. Within a generation, you'd have Mukhtasar al-Majalla. You'd have the abridgment of the Majalla. Mushd al-Hayran, but it has a lot of applied issues, new issues. They gave fatwa on many new things. So in many things they left the position of Zahir al-Riwayah, for example, for good reason, by committee. Mushd al-Hayran doesn't do that. But each has things that the other doesn't. Many people say, well, we have the Majalla, who needs Murshid al-Hayran? Al-iktifa' min al-taqsir. Finding sufficiency in one thing from another is from falling short. And this is a big problem. This is a big problem. This was particularly amongst cultures, particularly from something that the Arabs did harmfully. Right? This is of the things that harms marriage. Right? It was from, but habits take time to die. Right? And the Arabs have retained this as a bad habit, as a cultural bad habit. Right? Particularly amongst the ignorant. The ignorant. Right? And it's an expression of folly, of unprincipled action. So now there are situations where this may have use, right? It may have use. And someone could even make this as part of their marriage, right? A morbid legal marriage, right? They say, look, I cannot accept that so let's say someone married a lady who converted, but I actually met someone like that. It was like a very awkward situation because this lady came and introduced herself. She was like, wearing hijab. I said, Assalamu alaikum, my name is this, I'm a belly dancer. Like, why do I need to know this? But it's complicated. It's a real situation. That's the only job, like I don't know, she was presumably in her 40s, maybe 50s. She'd been belly dancing all her life. That's the only job she had. So outside of her work, quote unquote, she wore hijab. Let's say she got married to somebody and he said, if you belly dance, you're divorced. I will provide for you. But someone likes the tips or whatever, they decide. So in some situations, it could be a feasible thing that you give it a threat and you had a good intention. But the overwhelming use of it is that it's harmful, but there is situations where there would be reason for it. So he tells us, وَأَلْفَاظُ الشَّرْطِ, right? The words of shart are in, وَإِذَا, وَإِذْمَا, وَكُلْ, right? Are if, and if, in and إِذَا are similar. إِذْمَا, if and when. وَكُلْ, every, right? So someone said, every, so someone said, if you enter the house, you're divorced. Said, if every time you enter the house, you're divorced, right? But the divorce, so kul is something that enters into a condition. It's not a condition in itself, right? So it's mulhaqun bishart, right? It is mentioned with the shart, right? So, for example, someone says, "Kullu imra'atin atazawwajuha فكذا وكذا, right? فهي طالق. And if someone said, any woman I marry is divorced, right? Then every time the guy marries, as soon as a nikah happens, a divorce takes place, right? وكلما, whenever, right? ومتى, when, وما, right? And so he says, ففي كل هذه الشروط, in all these conditions, إذا وجد الشرط انحلت اليمين. It says in each of these conditions, if the condition is found, the yamin, the oath, ends, right? Because these expressions don't indicate لأنها غير مقتضية للعموم, because they're not general and do not connote repetition. So if the action takes place once, the condition is fulfilled, and the condition and the yamin does not remain, except إلا في كلما, except in whenever. فإن الطلاق يتكرر بتكرار الشرط, because the talaq there is repeated with the repeating of the condition, because that indicates generalization of the action, right? حتى يقع ثلاث تطبيقات. So it says كلما دخلت الدار فأنت طالق. Every time you enter the house, you are divorced. That's very, very serious, right? And some of the ulama try to figure out hilas around this, etc., but it counts, right? It's meant to be. So what do? You'd have to move into another house, right? Because it counts, right? This condition cannot be lifted. Why? So that people take it seriously, right? That don't do these things, right? Shaykh Nuruddin Itr has a book called Abghadul Halal, the most odious of permitted matters, where he discuss. It's now like 40 years old, but discussing, the many challenges related to divorce, what causes it, etc. So the wisdom of the legislation of divorce, etc. And it's one of the more important contemporary works on the topic. So until 3 divorces happen, right? فإن تزوجها بعد ذلك وتكرر الشرط لم يقع شيء. But if he marries her, i.e. validly, right? Validly, meaning, so she got divorced 3 times. You married her validly, meaning after she married someone else, consummated the marriage and divorced it, and the iddas all took place, etc., then it wouldn't count لزوال الملك, right? Because then the right that he possessed, which was in that state of marriage, is now over, right? فإن وجد الشرط في ملكه انحلت اليمين ووقع الطلاق، وإن وجد في غير ملكه انحلت اليمين ولم يقع شيء. So if the condition is found while she is still married to him, then what happens? So if this is in general, right? Someone says, إذا دخلت الدار فأنت طالق, right? He said that to her. So they're having a tough marriage. She didn't enter the house, but then he divorced her anyways, right? and then she did enter the house after the divorce, and let's to keep it simple, the iddah is over, she entered the house to pick up her belongings. So in that case, what would happen? Right? No, because they're not married now. So if she, let's say, said, if you enter the house, you're divorced. He said that to her, right? If they're married, what would happen? She enters the house, she's divorced. But let's say she didn't enter the house, right? So Zubayr told Zubaydah, if you enter the house, you're married. She didn't. She made an arrangement. She lived, her father's wealthy, he bought her the house next door. So Zubayr would go visit Zubaydah. He divorced her. The iddah finished in the house next door. After the iddah, she entered the house. The condition was found. She entered the house. Would a divorce count? No. Why? Because the marriage does not exist. But the condition, the premise of the condition was found. If you enter the house, so what happens? That was like shooting a blank, right? Right? دخلت الدار, but the condition couldn't apply. So what happens? So he tells us, right? So this is the Surah Al-Masala, right? وَإِن وُجِدَ فِي غَيْرِ مِلْكِهِ إِنْ حَلَّتِ الْيَمِينِ. If the pronouncement of divorce is found when he did not have the right to divorce her, because she's already divorced, the oath, the yameen, is fulfilled. وَلَمْ يَقَعْ شَيْءٍ. But nothing counts because you can't divorce someone you're not married to. So then if they get married after that, and then she moves in, would that divorce count? No. Because you already shot the bullet. Right? Right? So now, what if they differ? Right? وَإِذَا اخْتَلَفَا. If the husband and wife disagree. فِي وُجُودِ الشَّرْطِ. With respect to the presence of a condition, فَالْقَوْلُ قَوْلُ الزَّوْجِ فِيهِ. Then the word is the word of the husband. Now this is a tricky thing, because in transactions, human interests differ. And when human interests differ, the assumption is that each person will act according to their actual or perceived self-interest, right? That's a reasonable expectation. And if that happens, then it is expected that if they differ, if they're in disagreement, each will claim that which supports their. So there are principles of governing this, right? And some of the scholars put, so there's governing principles, and they tried, and in different situations you have to figure out, the asl is who is affirming, al-muthbit, and who is the one affirming and who's the one denying. And it's not always that simple, right? So there's a series of principles that one, right, has to get down. And there's a number of primary texts that this relates to, and this comes up in different chapters. But it's something you have to get the hang of. These things don't arise in worship, right? That's why the battleground of nuances is not worship, right? Although that's so important, but it's like anybody can figure out the field of worship. The real is that can you get the nuances outside worship, right? So one of the foundational basis of this is the Prophet ﷺ said, "Al-bayyinatu ala al-mudda'i wal-yaminu ala man ankar." Right? There's the one who's making a claim must provide proof. Al-bayyina. It's one of the hadiths of the Arba'in al-Nawawiyya, right? Al-bayyinatu ala al-mudda'i, correct? Wal-yaminu ala man ankar. And the one who denies must swear an oath. So there's the muthbit and there's the nafi. There's the one who affirms and the one who denies. Um, so, so if the husband says there was no condition, and she says there was, in دخلت الدار فأنت طالق. So he says, right? So he says, the word of the husband is expected لتمسكه بالأصل وهو عدم الشرط, because he's arguing what's the asl, which is there's no condition. So I divorced you. I'm not going to pronounce it again. Why? You have to remember, Arabs are people, I'm not going to do it again. Right? And you have to keep in mind, Arabs classically believed in honor. Now, honor with uprightness works. Honor without uprightness causes a mess. In many Arab countries, you have traffic jams. Why? Because two people, have you seen this? Right? Their cars are face to face and neither will move. And then 40-minute traffic jam. You have to move. The police will come and they will say, shoot me. Wallah, amut wa la ataharrak. I'll die and I'm not going to move. But you have to understand that, you say you could rob an Arab, but don't insult him, right? Right? It's one of those weird things, right? Insult me and yalla. Someone else say, just insult me and leave me alone, right? Anyways, so he's refusing to divorce. He says, I already did it, khalas. He says, no, but you said, if I eat cheesecake, in akaltu, cheesecake, in akaltu cheesecake, فأنتِ طالق. So what happens? It's his word, because he's holding to the asl that there's no condition. She doesn't want to be divorced. إلا أن تقيم البينة, right? Unless she establishes the proof. Because لأنها مدعية, because she is the claimant, right? And she's claiming, because what is the ziyada? The ziyada is, the asl of the talaq is, there's no condition. She is claiming that there is a condition. They both agree that a divorce was pronounced. She's claiming it was pronounced with what? With a condition. That's a claim. And the principle is al-bayyinatu ala al-mudda'i. The one making a claim must provide the proof. And of course, this gets tricky. Right? This gets tricky, and a number of scholars, Alam al-Hamzawi, so there's many treatises on this. This comes up in the chapters related to, and sometimes people say, the chapters on qada, I'm never going to be a qadi, but a lot of the principles, قواعد البينات والشهادات, the principles related to proofs, to giving witness, etc., these have to do with day to day. And we're morally bound to judge based on those things. Right? So, and then a number of the ulama wrote specific treatises on al-qawlu liman and qa'id al-bayyinat, etc. Amongst them, Alam al-Hamzawi was the Mufti of Damascus after the time of Ibn Abdin. He was a very interesting person. He was very gifted. He could shoot like a rifle with one hand without aiming and shoot down a pigeon from the sky. He could write the whole Fatiha on a grain of rice. They have it actually at the Qasr al-Azm behind the Umayyad. I never entered the Qasr al-Azm. The ulama relate that it's there. I used to have a book which had a picture of it. I never looked at the picture. Okay, he did it. Who cares, right? But a very interesting individual. He's very smart mufti as well. He also wrote a tafsir of the Quran bil huruf al muhmala, wrote a tafsir of the whole Quran without any dotted letters. It's published actually, Tafsir al-Hamzawi. And because in disputes between two people, who's making the claim and who's denying? That's a matter of procedure, but there are principles in fiqh related to that. فإن كان الشرط لا يعلم إلا من جهتها فالقول قولها. And if the condition is only found from her, then her word is accepted. في حق نفسها, but regarding herself. How? مثل أن يقول لها, such as if he says to her, إن حضتي فأنت طالق. If you, when you have your period, you're divorced. فقالت قد حضت. I have had my period. Her word is accepted with respect to her. So she would need to enter the iddah, etc. But if he doesn't believe it, right? قد حضت طلقت. Right? She is divorced, right? 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 وإذا قالت إن حضتي فأنت طالق وفلانة, right? فقالت قد حضت طلقت هي ولم تطلق فلانة. If the man has two wives, he says, when you have hayd, you're divorced and Zubaydah is divorced. And Zubaydah. So when she says, I had my hayd, Lubna gets divorced, but it does not apply to Zubaydah. Right? Because with respect to Zubaydah, she's making a claim. So there needs to be proof. So we'd have to verify that she did get her period, for example, right? وإذا قال لها إن حدتِ فأنتِ طالق فرأت الدم لم يقع الطلاق. But if he says to her, if you have your hayd, you're divorced, the divorce does not occur. أي لم يقع الطلاق أي حالا, it doesn't occur immediately. حتى يستمر ثلاثة أيام, until it lasts 3 days, because that applies to because the minimum hayd is 3 days. When a woman sees blood, تعمل ظاهرا على أنه حيض. Right? She acts outwardly that this appears to be hayd. What it actually is will become determined once events unfold. Right? Right? Because it could stop before it. Right? Right? And in Ibn Abdin, if you want to put in from the Bulaq edition, volume 2, page 505, this issue of if he says, if you have hayd, you're divorced, and so and so is divorced, and she says, I had my hayd, it only applies to her. This occurs if the one divorcing says, no, you didn't. With respect to herself, so Lubna, he says, Zubayr says to Lubna, because this drama happened, right? Zubayr married Lubna, and then he regretted it, so he also married Zubaydah, but it's led to 2 spoilages, not 1. So he decided to divorce. Says, when you have hayd, you're divorced, right? And Zubaydah. So Lubna says, I had my hayd. If Zubayr doesn't believe it, with respect to Lubna, it counts. But with respect to the other one, we need to prove the issue. It gets tricky. This is so Ibn Abdin explains, right, that يعني إن كذبها الزوج, if the husband denies it, right? If the husband denies it. فإن صدقها, but if he accepts what she's saying, أو علم وجود الحيض, or he knows that she had hayd, right? By the signs of it. Both are divorced. Now, if neither occurs, what happens to the status of Zubaydah? You could look and find out. But now going back to the issue, if someone's bleeding starts, he says, فَإِذَا تَمَّتْ ثَلَاثَةَ أَيَّامٍ حَكَمْنَا بِوُقُوعِ الطَّلَاقِ. So someone, if it's said, when your hayd starts, you're divorced, it's not by the first blood that she's divorced, but once 3 days pass. Right? So once the 3 days passed, she would be deemed to be divorced. But from when? Min hina hadat, from the time of her hayd, which affects a number of different rulings. Right? وَإِذَا قَالَ لَهَا إِذَا حِضْتِ حَيْضَةً فَأَنْتِ طَالِقٌ. If you have in حِضْتِ حَيْضَةً, if you have hayd, if you have a full hayd, you are divorced. لم تطلق حتى تطهر من حيضها. Right? In حِضْتِ حَيْضَةً, it refers to a full hayd. If you have a full hayd, she would not be divorced until her hayd finishes. Right? Because of the implications of the language. Then he says, وَطَلَاقُ الْأَمَةِ تَطْلِيقَتَانِ. A slave woman's divorce is 2 divorces, not 3. حُرًّا كَانَ زَوْجُهَا أَوْ عَبْدًا, whether the husband is free or a slave. وَطَلَاقُ الْحُرَّةِ ثَلَاث. Right, and the maximum number of talaqs for a free woman is 3. حُرًّا كَانَ زَوْجُهَا أَوْ عَبْدًا, whether her husband is free or a slave. And this is because both divorce and the iddah period are counted by the state of the woman in our madhab. وَإِذَا طَلَّقَ الرَّجُلُ امْرَأَتَهُ قَبْلَ الدُّخُولِ بِهَا ثَلَاثًا وَقَعْنَ عَلَيْهَا. So then we look at derivative rulings, and we have one more lesson left, بإذن الله, to complete the section on divorce. This is not the most exciting of chapters in terms of increasing in our spiritual inspiration and so on, right? But they are important principles, and these are things that these principles, the intelligent person judges things by their consequences, and the consequences of this are very important because this has to do with the preservation of people's marriages and also the broader preservation of human well-being and the wisdom of the rulings, as Shaykh Hassan would reiterate, of the rulings where they're punitive is for people to take heed, because actions have consequences. وصلى الله على سيدنا محمد وعلى آله وصحبه وسلم والحمد لله رب العالمين. For those who are catching the recording, we apologize for not streaming it live.